Okay, Rule 126, Search and Seizure. This is the last section in criminal procedure and the last rule in criminal procedure. So, search warrant is defined as an order in writing issued in the name of the people of the Philippines, signed by the judge, and directed to a peace officer, commanding him to search for personal property described therein and bring it before the court. So this is a very important definition. We also have to take note that search warrant is not applicable in civil cases. Why? Because a search warrant is a criminal procedure cases. And so also, only a judge can sign a search warrant. It must describe the thing to be seized and the place to be searched. Otherwise, it is a general search warrant and it is void. It can only be issued for one specific offense. Otherwise, it is a scattered shot search warrant and it is also void. Unlike in subpoena and summons, which can be issued by the administrative bodies authorized to investigate, a search warrant can only be issued by a judge. So it can be, the definite lifetime of a search warrant is 10 days from its issuance, and after 10 days it becomes functus officio. So unlike in warrant of arrest, there is no lifetime, no. It is its life is available, or it is effective until it is served. Yan, sa warrant of arrest. Search warrant, 10 days lang. And it can only be implemented once, except for reasons beyond their control, provided it is still within the 10-day period. So, Section 2, the court where application for search warrant shall be filed. An application for search warrant shall be filed in the following: 1. Any court within whose territorial jurisdiction a crime was committed, and for compelling reasons stated in the application, any court within the judicial region where the crime was committed, if the place of the commission of the crime is known, or any court within the judicial region where the warrant shall be enforced. However, if the criminal action had already been filed, the application shall only be made in the court where the criminal action is pending. So, yun. Section 3, Personal Property to be seized. A search warrant may be issued for the search and seizure of personal property, subject of the offense, stolen or embezzled, or other proceeds or fruits of the offense, or those used or intended to be used as the means of committing the offense. Requisites in issuing a search warrant. So, a search warrant shall not issue except upon probable cause in connection with the specific offense to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, particularly describing the place to be searched and the things to be seized, which may be anywhere in the Philippines. Section 5, Examination of the complainant. So the judge must, before issuing a warrant, personally examine in the form of searching questions and answers in writing and under oath the witness, the complainant and the witnesses he may produce on facts personally known to them, and attach to the record their sworn statements together with the affidavit submitted. Section 6, Issuance of form of search warrant. So if the judge is satisfied of the existence of facts upon which the application is based, or that there is probable cause to believe that they exist, he shall issue a warrant, which must be substantially in the form prescribed by these rules. Section 7, the right to break door or window to effect the search. So the officer, if refused admittance to the place of directed search after giving notice for his purpose and authority, may break open the outer or inner door or window of a house or any part of the house or anything therein to execute the warrant, or liberate himself or any person lawfully aiding him when unlawfully detained therein. Section 8, the search of the house, room, or premise to be made in the presence of two witnesses. So, there must be a witness. So, the officer, if no search of a house, room, or any other premise shall be made except in the presence of a lawful occupant thereof, or any member of his family, or in the absence of the latter, two witnesses of sufficient age and discretion residing in the same locality. Section 9. The time of making search. The warrant must direct that it be served in the daytime unless the affidavit asserts that the property is on the person or on the place ordered to be searched, in which case a direction may be inserted that it be served at any time of the day or of night. So, hindi kagaya ng search ay ng warrant of arrest, it can be effected at any time, any day, or night. So, dito naman sa search warrant, it shall be served in the daytime unless there is an affidavit that asserts. No, yan yung sinasabi niya sa Section 9. Section 10, the validity of the search warrant is for 10 days from the date, and thereafter it shall be void. Section 11, receipt of the property seized. So the officer seizing the property under the warrant must give the detailed receipt of the same to the lawful occupant of the premises in whose presence the search and seizure were made, or in the absence of such occupant, must, in the presence of at least two witnesses of sufficient age and discretion residing in the same locality, leave a recipient in the place which he found the seized property. Section 12. Delivery of property and inventory thereof to the court. The officer must forthwith deliver the property seized to the judge who issued the warrant, together with the true inventory thereof duly verified under oath. 10 days after the issuance of the search warrant, the issuing judge shall ascertain if the return has been made, and if none, shall summon the person to whom the warrant was issued and require him to explain why no return was made. If the return has been made, the judge shall ascertain whether Section 11 of this rule has been complied with, and shall require that the property seized be delivered to him. The judge shall see to it that the subsection A hereof has been complied with. The return on the search warrant shall be filed and kept by the custodian of the logbook on the search warrants, who shall enter therein the date of the return, the result, and other actions of the judge. A violation of this section shall constitute contempt of court. Section 13. Search incident to lawful arrest. A person lawfully arrested may be searched for dangerous weapons or anything which may have been used to constitute proof or in the commission of the offense without a search warrant. In Section 14, a motion to quash a search warrant or suppress evidence where to file. A motion to quash a search warrant and or to suppress evidence obtained thereby may be filed in and acted upon only by the court where the action has been instituted. If no criminal action has been instituted, the motion may be filed in and resolved by the court that issued the search warrant. However, if such court failed to resolve the motion and the criminal case is subsequently filed in another court, the motion shall be resolved by the latter court.